Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is a civility program stemming from our Curious Lawyer series, and is a look at civility issues in the context of lawyering with fun deposition clips to watch. We will see depositions of lawyers fighting in absolute melees, and clients engaging in uncivil and improper behavior. We ask, where does civility benefit us and where does overaggressive behavior actually hurt us? Does civility actually help us be better advocates? Where do we face the line of civility and sanctions for behavior? You may cry or laugh at the clips, but I know you will be surprised. But first, and briefly, I want to tell you more about the Curious Lawyer series that we have created for you. A true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs. And of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking exploration of civility. As a starting point, let us watch this video clip of a deposition where we will see all manner of fighting between lawyers and the witnesses. This is a good place to start our civility program because it touches on all aspects of civility we will be addressing today.
Did you talk to this man sitting next to you before this deposition started?
Yesterday, but he had nothing to do with
I didn't ask you that.
Did you I said it though, didn't I?
Did you talk to him, sir? What did you say?
I said nothing. I said, you have a case of incipient verbal diarrhea.
Oh, sir, we're going to see about that.
Well, good.
Did you talk to him yesterday?
Yes.
How long?
About 3 hours.
Talk about this case?
Yes.
Did you tell him the other companies you consulted for?
No. I did
You're
not.
under oath here.
I did not.
We'll see about it. When you were at Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
Research chemist.
And was that your title during your entire stay at Texas City?
Texas City, yes.
Don't talk over each other.
After you left Texas City.
Wait a minute, let me ask a question here.
Yeah.
You represent this guy or not?
Who are you?
My name's Tucker, and I represent Ayrshire, and I just want to know, do you represent the guy or not? I'm getting, if you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Why don't you keep your mouth shut? I'll do what I want.
No, you're not
Hold
going to
it.
do what you want.
Oh, wait.
I'll do what I want.
No, you're not.
No, you're not.
Yeah, I am.
That's
I'm gonna make
bullshit.
whatever objections I want to make, and I'll make them as loud as I want to make them. Now you just shut your mouth, and we'll keep the record straight.
Don't tell me to shut my mouth, boy. You may be big, but you want to see how bad you are? Come on.
And I wouldn't try that, Ed.
Are you threatening to fight?
Hold on just a second.
No, I want to know whose side we're on. We're going to be outnumbered, Ed.
Hold on just a second.
No, you got a big mouth. Now you do. Now, you need to either represent the man or not.
I'm
Not tolerate
representing
it.
Monsanto, and I'm
But
making
you're
an
not-
objection on the record.
Then you're not entitled to be his lawyer then, okay?
I'm not representing the man.
Well,
I'm
you're
making
trying
an
to be.
objection on the
And
record.
another thing,
Don't tell
you
me what
don't.
I'm trying to do.
Yeah, I'm going to tell you something else. You don't run this deposition. You
Neither
understand?
do you, Joe.
You watch and see. You watch and see who does. Big boy.
I'm telling you, Joe.
Oh, you ain't telling me a goddamn
I'm gonna make
thing.
whatever objections I want.
You can make your objections and
You can
keep
talk as loud
quiet.
as you
See?
want. No,
But
I'm
don't be
not
telling
gonna
another
be
lawyer
quiet.
to shut up.
Don't be
That
telling
ain't your
me to shut
goddamn
up.
job,
No, that's not
fat
your
boy.
job.
Now
Mr.
get back.
Fairpiece.
Now you got
As I
time
said
to answer
before,
me?
you have an
Hold on just a
incipient
second.
bad
What do you
mouth,
want
don't
to do
you?
about it, asshole?
Oh, I'd like to knock you on your
Wait a
ass.
minute.
Come
I'm
try
not
it.
gonna do
Wait a
that.
minute.
Come over here and try it, you
Wait a minute.
dumb son of a bitch.
Wait just a second.
Come over here.
Hold it. Hey, wait a minute. Hold on.
close.
No way. Hold on.
When
Hold on just a second.
his associate are taking Mr. Garrett out in the hall to lecture him, I suppose. They're doing this over our objection. We started this deposition, unable to get an answer from this man.
Well, there you had it all. Yelling, name-calling, threats to fight between lawyers and witnesses, no less. You just can't make it up. The questions it raises, however, are whether that behavior helps a case or maybe hurts it because you damage your ability to persuade as an advocate. And as a practical matter, how does a judge look at this behavior? Now, I do not know if that clip ever made it before a judge in that case. And if it did, I am of the opinion that a judge would have harsh words, if not sanctions, for some of those folks. But we can start by looking at how courts treat incivility. Let's take a look at the quote from this case, which is pretty typical in terms of how courts address incivility among lawyers. Here it was a simple discovery dispute with improper objections to witnesses not to answer, which of course is not nearly as serious as offering to fight or engaging in name-calling that is demeaning to other people. And here the court said that loaded guns, sharp objects, and law degrees should be kept out of the reach of children. That is a pretty brutal statement, but I think it fairly encapsulates what we are talking about in terms of the importance of civility, both as a practical matter to avoid being sanctioned, but also as it drives more towards your integrity, your credibility as an advocate. You have to appear before the judge where you will need the judge to do things for your case. Be the small things such as extensions or deadlines, or big things such as addressing complex legal arguments you may be making. If the court sees you as someone who has effectively behaved as a child, you will not have the credibility you need on the big issues. This is why, as a practical matter, civility serves your interest, even if you feel like you're not being the pit bull dog that your client may want you to be. So with this depot clip we watched and this court ruling from a different case as our entrance point and framing materials, let's now look at where we are going today. We will be looking today, of course, at civility issues, and we will do a quick overview of the CLE requirements in this regard and some policy statements from California on civility as it relates to lawyering. And we will be looking at a variety of real-world deposition clips from Depositions in particular, where we can explore the issue of civility among lawyers and with our witnesses. We will give you tips for how you can maintain your credibility and best prepare your case and witness, all of which can be done within a framework of behaving in a civil manner. We will also look at the complexity of managing the famous or powerful or wealthy client who can be more difficult to manage given their status. We will also look at sanctions that can follow due to improper behavior in depositions and the disasters that follow. And we will look at a couple cases of incivility and improper behavior by judges, which itself is part of this equation. Ultimately, as part of this Ability continuing education program, we are looking at the tripwires that apply to you and can cause you to actually damage your ability to be a good advocate by behaving in an uncivil manner. This 1-hour civility program is framed by the California continuing legal education requirement that we do a program on civility within the profession of law. We can frame the requirement from a 2009 State Bar of California report that was issued called the Civility Toolbox. You can Google it and find it to read it all, but here I will give you a quick overview. The State Bar of California did not issue mandatory guidelines on civility in the practice of law, and instead issued a comprehensive report with 21 guidelines that frame voluntary goals of civility. At the end, there is a voluntary pledge that lawyers can sign to accord their behavior with the Civility Toolbox and California aspirational positions. Here are 2 important questions and answers from the California State Bar on this issue period. The first comma. If they are not mandatory, why should an attorney abide by them? The State Bar's answer is that civility in the practice of law promotes effectiveness and enjoyment of the practice of law. It also promotes economical client representation, period, and conversely, a lack of civility not only damages clients, but it demeans the profession and the system of justice as a whole. In this program today, I will be double-clicking on an aspect of effectiveness and civility that is not discussed enough, I believe, in our civility programs, and that is how civility can be a very powerful tool as an advocate to actually better persuade others of your position and maintain and develop your credibility as an advocate. Framed through that prism, whether you like it or not, I would argue that civility actually makes us better advocates, and so as a result, self-interest should cause us to behave in a civil manner. In this sense, I am double-clicking on that word effectiveness and opening it up for a more in-depth discussion of what that means and how it relates to our credibility as advocates and lawyers. The other question that is posed and answered is the following. Do the guidelines denigrate an attorney's duty of zealous representation? The answer is no from the State Bar. Our responsibilities to the administration of justice, the courts, the public, and other lawyers, as well as our clients, have certain levels of civility and professional integrity that define what it is we do. As a result, the appropriate mechanism of lawyering under this model is to engage in civil behavior which does not damage our ability to zealously represent our clients. Again, in this program, I am focusing on our credibility as advocates and how important that is as a tool of advocacy and how easily it can be lost with behavior that is not civil. As we walk through the program, we will come back to the guidelines and engraft them onto the video clips we watch. So let's get going and get ready for some fun deposition clips. I want to at first give you some of the actual guidelines from the California State Bar's Civility Guide, so you can see them in writing, as we will again refer to them and quote back to them. But they are useful for you to have in mind in terms of the aspirational ideas that circle around this issue of civility. These come from Section 4 and relate to our communications as lawyers and the importance of them reflecting civility and professional integrity and respect for the legal system at all times, period. So let's take a look at the various ones. A. An attorney's conduct should be consistent with high respect and esteem for the civil and criminal justice systems. E. This guideline does not prohibit an attorney's good faith expression of dissent or criticism made in public or private discussions for the purpose of improving the legal system or profession. C. An attorney should not disparage the intelligence, integrity, ethics, morals, or behavior of the court or other counsel, parties, or participants when those characteristics are not at issue. O. Respecting cultural diversity, an attorney should not disparage another's personal characteristics. E. An attorney should not make exaggerated, false, or misleading statements to the media while representing a party in a pending matter. F. An attorney should avoid hostile, demeaning, or humiliating words. G. An attorney should not create a false or misleading record of events or attribute to an opposing counsel a position not taken. An attorney should agree to reasonable requests in the interests of efficiency and economy, including agreeing to a waiver of procedural formalities where appropriate. Unless specifically permitted or invited by the court or authorized by law, an attorney should not correspond directly with the court regarding a case. We are going to unpackage many of these civility guidelines as we look at our deposition clips and some case law, so keep these handy as you watch our various clips throughout this program. So let's jump into civility in the practice of law and enter through looking at some depositions. As a framing principle, we should always keep in mind that depositions allow discovery, of course, and discovery is broad. At root, discovery should be liberally construed in order to take the game element out of trial preparation by enabling the parties to obtain evidence necessary to evaluate and resolve their dispute before a trial is necessary. Any doubt is generally resolved in favor of permitting discovery, particularly where the precise issues in the case are not yet clearly established. You can see the cites there. This breadth and liberality of discovery, of course, can lead to clashes, as we will see in a moment. And of course, discovery into matters that are relevant is broader than the issue of what may be admissible at trial. The evidentiary rules at trial may well be narrower than what is allowed in discovery, and this is often where we find collisions. For example, hearsay is not admissible, but hearsay can be discoverable from witnesses in order to delve deeper into the underlying facts and find further potential people to depose. You can see the basic case citation there for that principle of Smith versus Superior Court from 1961 in California. And this is a pretty standard principle across all jurisdictions. At the same time, matters that may be irrelevant may be allowed for discovery if it may lead to the discovery of relevant admissible material. That broad principle you can see in the case of Dodge versus Riley with the citation there. Let's see how this now plays out in a clip of Justin Bieber in a lawsuit by a celebrity photographer who sued Bieber when a Bieber bodyguard allegedly attacked the photographer.
You got Selena Gomez? Yes. Would you be dating her at some point in time?
What's the relevance of that? Why are you asking that question?
Because I'm allowed to ask.
No, you're not allowed to just make up stuff and ask it. What are you talking about?
It sounds like you're trying to harass him.
Be a lawyer, man.
Stop making
journalism. This isn't journalism.
What is the relevance? What's your pro offer?
Have you ever?
What's your
if
pro
you have an objection, state your objection.
What's your pro offer of relevance on that?
Sir, have you ever talked with Selena Gomez and discussed your feelings about paparazzis with her?
Don't ask me about her again.
Sir.
Move on to another.
Have you ever?
Don't ask me about her again. Don't ask me about her again.
Have you ever?
Don't ask me about her again. Don't ask me about her again.
Wait, let's take a break.
You know what? Just stop.
You gotta take a break.
Don't ask me about her again.
You gotta take a
The
break.
client's not asking for a break.
Don't ask me about her again.
Let's take a break, Justin.
302.
Well, there you saw quite a disagreement. We had a famous client engaging in that behavior and lawyers fighting about what was relevant. We saw one lawyer telling the other to be a lawyer man. We saw him ask the relevance and demand an explanation. And we saw the client all but explode. We saw a client saying those things with his middle finger up on his forehead. I think in my opinion there was a lot of lack of civility there. Telling someone to be a real lawyer is what would fall within the lack of civility standards of the state bar guidelines. For example, Section 4C of the guidelines says, an attorney should not disparage the intelligence, integrity, ethics, morals, or behavior of the court or other counsel, parties, or participants when those characteristics are not at issue. Let's now look at this clip of a lawyer instructing a witness not to answer and engaging in argument with the other lawyer.
Thanks for telling me the questions I should ask. You will have your opportunity at the end.
Just
of
shut
my
up and move
questioning.
on with your questions, okay?
Mr. Curry.
Just shut up, or I'll adjourn this deposition, and you can tell it to the judge, or I'll get you some tissues and you can cry.
Mr. Curry.
All right?
Please don't tell me what to do.
You asked him if he ever spoke with Farsh about anything. He said no. Now you're asking him to tell you what Farsh told him. It is a bullshit question. It is absolutely speculative, no foundation, or anything else. Now, he's entitled to a fair question. You told him that. So if you're going to sit there and ask unfair questions, I'm going to correct them. So I don't waste this guy's time having to come back or go to trial and undo the mess that you're trying to create. Got me?
Are you finished?
Are you finished?
Are you
Do you understand the question,
Are
Mr.
you aware
Chair?
of the local rules
Mr.
with
Foster?
regard to what objections you're allowed to make and what
Do
you're
you
not?
understand the question, Mr. Foster?
Sir, right now this is my witness. I get to ask the questions. You get to make objections only. There are two types of
Call the
objections you
bailiff.
can make. Objections
Call
to
the
form.
bailiff.
Sir.
Do you understand the question being asked, Mr.
Mr.
Foster?
Curry.
Don't ever presume that you get to tell me what to do or when to do it, counsel. Don't you ever presume.
Why
Mr.
should you
Foster,
be
this is
entitled-
your deposition. Do you understand the question?
Why should you be entitled to then tell me what to do? Doesn't it go both ways?
Because I'm being straight with the guy and you're being not straight with the guy. That's why. He has no dog in this fight.
Are you finished giving your opinions now about
He has
the
no
question?
dog in this fight, and you're trying to get him to say things that are simply untrue. It's an old trick, Mr. Zohar.
You don't think you're trying to coach the witness right now?
I'm telling him what the question is so he can answer it.
Do you know what speaking objections are?
Don't lecture me, idiot. I'm telling you I'm not gonna let that happen. Okay? You got me? Do we understand each other? Are we connecting here? Because if we're not connecting here, I will try again. Okay? Don't give me local rules, don't give me procedures, don't give me professionalism. Just put a fair question to the witness. And if you're not going to do that, then I am. We understand each other?
If you believe that a question that I ask is not proper, then you get to pose a valid objection. You're not allowed to make speaking objections. You're not allowed to give your
Don't lecture me,
opinions.
puppy. Don't lecture me. I was doing this when you were still chasing cheerleaders. Don't you even think about lecturing me about depositions.
I think you're practicing a few years more than me, actually. That's it, to be honest with you.
Do you understand?
Wow. So let's look at that clip and dissect it through the civility prism. 1. We had the lawyer telling the asking lawyer that the lawyer could not ask a question and was cursing. He told him to shut up and he could get tissues and cry. You cannot make this up. Then we had the one saying, "Do not presume to tell me anything," angrily, calling him an idiot, a puppy, and referencing the other lawyer chasing cheerleaders. Back to the guideline. An attorney should not disparage the intelligence, integrity, ethics, morals, or behavior of the court or other counsel, parties, or participants when those characteristics are not at issue. Check, I think, there. Guideline 4A says, an attorney's conduct should be consistent with high respect and esteem for the civil and criminal justice systems. Check again, I think. And Guideline 4F says an attorney should avoid hostile, demeaning, or humiliating words. Check again, I think. Now let us go back to the powerful, rich, and famous clients and see how they trigger civility issues.
Clearly, Lil Wayne answers to no one.
Is that an interview that you actually gave with Katie Couric?
Is that an interview that I actually gave with Katie Couric?
Yeah.
What's your name again?
Well, that's not the question.
What's his name?
Pete Ross.
Huh?
Pete Ross.
Pete Ross.
Yeah.
That's a stupid-ass question. You just saw me on there giving an interview with her.
Okay. So that was you. Did you perform at the Virgin Mobile Music Fest in 2008 with Kanye West?
I don't know, but I know I did perform at this badass bitch birthday party recently. She was crazy, stupid thick.
Isn't it something that you would remember if your album, The Carter 3, was the biggest selling album of the year in 2008?
Isn't it something that I would remember that?
Yes.
Isn't that a personal opinion type question? Cause that's why I got that. I mean, because I would be actually answering the question to, isn't it something? That's my question. Isn't it something?
That you would remember.
Isn't it something? That's the question I have to answer, Your Honor.
Go ahead.
Isn't it something?
You could do the best trying to answer it.
Yeah, something out of your ass. That's my answer. Yeah, it is something out of your ass.
Have you ever hired a photographer to photograph an event?
Have I ever hired a photographer to photograph an event? Sorry, sir, no, I'm a superstar. People hire them themselves to photograph me. We don't hire them.
How would you describe your image in the media?
How would I describe my image in the media?
Yes.
I wouldn't describe it.
Well, how would you describe it if you had to?
I don't have to.
Well, what image are you portraying in the media?
I don't portray anything. I am who I am, and you guys portray what you get.
No, who are you? Who is the real?
I am Dwayne Michael Carter Jr.
Okay. Do you like to portray yourself as?
I just answered that and said that I don't like to portray myself as nobody.
Okay.
I completely be Dwayne Michael Carter Jr. I don't portray myself as anything. An image is self-described.
Well, you have to wait till I'm done with the question.
I don't have to wait to anything, honestly. I mean, this guy right here may tell me that I have to wait, but personally, I don't have to do nothing.
Go ahead, ask the question.
Thank you, Your Honor. Do you like
He can't save you, right? In the real world. That guy right there. He can't save you in the real world. Just so you know.
What does that mean?
I don't have to elaborate.
Wow, there we see a witness who self-claims to be a superstar, refusing to participate and trying to anger the lawyer. We even saw what could be interpreted as threats with the reference to the judge being unable to save the lawyer in the real world. That is a stunner of a statement if you ask me. And we saw the lawyer stay calm and not get angry or rude back. That was an example of proper civility, I think, in the face of a difficult situation. This and the earlier one are good examples of the famous and powerful, whether in fact or self-perceived, and the importance of not letting oneself as a lawyer get dragged into the gutter. In other words, as Guideline 4A says, an attorney's conduct should be consistent with high respect and esteem for the civil and criminal justice systems. I think this lawyer in this clip we just saw did that. So let us now go from these clips we have seen into the issue of civility, and how civility actually can help us be better lawyers and advocates. As we have already seen, the civility guidelines are aspirational and are built around the idea, among others, that a lawyer who follows the civility guidelines will be more effective. I think from these clips we have looked at, we can now dive into a deeper look at what it means to be an effective lawyer. This lets us double-click on that concept and unpackage it so that we can look at some specific attributes of advocacy and lawyering that are impacted by a lack of civility. The three major areas that are impacted by a lack of civility and that ultimately damage your ability to be the most effective advocate you can be involve lost opportunities to advance your case, damage to your credibility, and lost objectivity. All three of these relate to civility and effectiveness of lawyering. Let's now go into more detail on all of them. I am going to give you a hypothetical that we can work from to explore the lost opportunities concept in the context of fact discovery and depositions. Let us assume that the other side gives you a great email in discovery. It is something that you think wins the day. You get to have the proverbial, you can't handle the truth moment as a lawyer. Maybe, but often that falls flat in a trial and you do not get what you think you are going to from it. So slow down and methodically work the problem. Maybe there is a better way to achieve advocacy goals within a civility rubric. Back to our great email hypothetical. The email says what we want it to say as it comports with our theory of the case. We can do three things. 1. Set up impeachment and impeach then on the spot right away to nail them down in the deposition. 2. Or we can set up with foundation and the like and hold for trial. Which is best? Almost always number 1. After all, most cases settle anyway, so we lose settlement value of that ammo if we hold it back. And the 2nd of May goes south at trial. Remember the famous glove fit acquit event form the OJ trial? When trial is inevitable, no witness cannot wiggle out. But what if you just calmly use the document to get the witness to give fact testimony about it, so now you have their key witness hewing to your story? That is better than impeachment almost always. Put their document in front of them. They feel compelled to buy into what they wrote. They told truth at the time, obviously. That is a civil event within depositions and avoids a lack of civility in explosions and arguments, and this lets you be a more effective lawyer often. So that is an example of how civility can actually make you a better advocate. as opposed to banging your chest and being aggressive, which may well cause more damage to your case than simply doing your thing with your head down and being civil. The second issue relates to credibility and how important and difficult it can be to get it, and how easily one can lose it. When I am talking about credibility, I am talking about the fact that the words of a message we deliver never stand alone. They are always tied to, and to some extent dependent on, the messenger. That is, the strength of our message does not depend entirely on the case law we cite or the documents we reference. How our audience receives us, whether it be the judge or your opposing counsel, impacts how they receive the content of our message. In this way, our credibility as an advocate matters, sometimes decisively. From the ancient world, we have Cicero, the greatest orator from the ancient Roman world. His famed work on advocacy has survived 2 millennia, and he had one key message that travels through time to us today and matters as it relates to civility. His message then, quote, "All my efforts are always concerned with this goal, for I will say it again and again, to do some good by my speaking, if I can, and if not, at least to do no harm." End quote. A lack of civility can do great harm and may not do any good, and that simple formula frames the civility question. Another way to look at it is, whether in war, smart generals defend every inch of territory, or if they sometimes make concessions and give up ground, so that they may win the larger war, even if it means losing a battle or retreating at some point. For us as advocates, this is another way of saying that to win does not mean that you have to fight every single thing the other side does or says, even though they are our adversaries. There may be some things they say which are correct, or which do not need to be opposed simply by reflexively being oppositional. With this in mind, you can maintain civility and also be a better advocate. I give you this quote from the very famous old book, The Fog of War, which title of book you may be familiar with from the documentary in the last 15 years after the Iraq War. The old book on war strategy and battles said the following: "Every unnecessary expenditure of time, every unnecessary detour is a waste of power, and therefore contrary to the principles of strategy." End quote. This is a military strategy version of what the advocate Cicero gave us, and which we are talking about today in terms of using our words to maintain and establish credibility, and that is achieved by not being inappropriate, demeaning, nasty, or lacking in civility. If you go back to the videos that we just watched and you put all of them through this prism, you will see what I am saying in terms of the injury to credibility that follows with that behavior. At some point, you need to speak to the opposing counsel or the judge in the case, and if they do not actually respect you because you have been so demeaning or insulting, then you are in a position where you cannot even advance your client's goals necessarily because you have such a bad relationship with opposing counsel, and or you have made opposing counsel not trust you or not even see you as a credible advocate. Civility is maintained when you do not get lost in the fog of war. Another place we see civility collapsing is when we are caught flat-footed, or we make a mistake and we are unable to make the concession that we erred. Sometimes it is ego. Sometimes it is simply the fact that we have a hostile relationship with the opposing side, and that causes us reflexively to fight everything. And this is an area where your credibility and civility can be developed, maintained, by seeing an opportunity and sometimes making a concession, as opposed to seeing it as a sign of weakness. First, an honest person admits his weaknesses, and that is a truism that we all understand at 30,000 feet. We also see it as we pivot back to our State Bar guidelines in Section 4E and G that says an attorney should not make exaggerated false or misleading statements and should not create a false or misleading record of events or tribute to an opposing counsel a position not taken. This is another way of demanding honesty. If we follow these civility guidelines, then it inures to our benefit because we have a greater chance of being seen as honest, and you will need that when you go to negotiate with the other side or the judge over a settlement of a case or the outcome of a law in motion matter. In this sense, then, civility is a tool that actually benefits us as advocates and is not remotely injurious to our advocacy. The social sciences also talk about this, and if you want to dive deeper into this, you can watch any of my 5-pack of advocacy programs that are available through this platform, where there is a much deeper dive into the value of this in terms of advocacy and persuasion. But for purposes of civility, the main point is that sometimes making a concession can facilitate the other side to make a concession back in this act of reciprocity. And this is critical for us to take advantage of and use. And so, if you do need to make a concession, see it as a potential gift that you can take advantage of and turn into lemonade, as opposed to seeing it as a lemon. One aspect of credibility that's worth mentioning is this quote from U.S. Supreme Court Justice Robert Jackson. Legal contentions, like the currency, depreciate through overissue. The mind of an appellate judge is habitually receptive to the suggestion that a lower court committed an error, but receptiveness declines as the number of assigned errors increases. Multiplicity hints at a lack of confidence. Multiplying assignments of error will dilute and weaken a good case and will not save a bad one. End quote. Now, this is just not a principle of appellate advocacy. It is a general principle that traverses everything we do in terms of overstating the case in any aspect. Every discovery request the other side serves on you believe is worthy of 40 objections, including ones that people have never even heard of. You're damaging your own credibility in terms of how the other side sees you. That act of oppressive objections is itself lacking in validity within the law, which makes it arguably lacking in proper civility. But more importantly, you're actually damaging your credibility as an effective lawyer, because the other side won't see you that way. For those of you who are more engineering or mathematically inclined, that quote I have converted here into a graph, at least with respect to the assignment of errors. But you could change the word error for objections, causes of action, or any other relevant noun that you can think of that we interact with as lawyers. In other words, if you go on appeal and say the trial court did 50 things wrong, as opposed to 2 things wrong, you are stretching your credibility past the breaking point. If in a simple breach of contract relationship, you turn it into 25 causes of action, you are doing the same thing. If someone seeks discovery and you assert 20 objections, there again, you are lacking in credibility. This is not to say, of course, that we are not zealous advocates, as we are and must be, but it is to say that we should do so in a manner where our disagreement has the greatest likelihood of having force. Civil disagreement is far more likely to engage the other side with you as being seen as a valid, legitimate advocate, as opposed to overaggressive, nasty hyperbole, which is far more likely to cause the other side to see you as being a less effective advocate. In this respect, look back on those videos we watched and put them through this prism. Our third major principle is objectivity, and here we are going to look at confirmation bias and the danger it poses to us as lawyers in terms of poor advocacy, and how that directly ties to behavior that lacks civility. Let's start with confirmation bias and what it is. Confirmation bias is where decision makers actively seek out and assign more weight to evidence that confirms their hypothesis and ignore or underweight evidence that could disconfirm their hypothesis. This creates a tendency to seek out information or to view things in a way that confirms what you already believe. Confirmation bias contributes to overconfidence in personal beliefs, even when faced with contrary evidence. As lawyers, we have to be hyper-aware of it because it can be our Achilles heel. It can affect our perspectives on things such as which route might be the best for a client, the strength of arguments they're making, discounting strength of the other side, which leads to negative client results. And we offensively look to see if it exists in the other side's experts. How do we lose sight of it and engage in confirmation bias as it relates to lack of civility? First, by uncivil behavior, reflexively disagreeing and rejecting everything the other side says. Second, getting angry at bad facts that hurt us, so we ignore them or undervalue them and engage in hyperbolic yelling and screaming. That reaction lacks civility and walks us down the path of confirmation bias. Thus, being uncivil can lead us down the confirmation bias path, and that is a bad path to be on as an advocate. Practice tip: what do we do? Maintain objectivity and awareness of confirmation bias. Do not get angry and yell. Stay focused. Being civil keeps you safe from damage. In this sense, civility pays. Here we are going to do our first look at civility between judges and the lawyers and parties before them. This is a 1970s case, and I highlight language in different colors for you to assess how the majority on the left and dissent on the right actually speak about the rape victim. This is a criminal case from the 1970s called Rusk versus State, and you can see the case at 43 Maryland Appellate 476. The basic fact pattern is as follows. A man was charged with rape of a woman, and the case goes up on appeal after his conviction. The appellate court reverses his conviction. The case is useful because it allows us to look at how the majority framed the evidence and how the dissent framed the evidence. And in that process, we can unpackage implicit bias, indeed perhaps even express bias. This is a particularly important example to look at, not just to shine a light on gender-related bias issues as they percolated through the judiciary in the 1970s and perhaps even today, but also to understand how the framing of facts and how stories are told is itself an exercise in advocacy and may well be an exercise in the employment of bias. These are things that we need to watch out for. As you can see, I have used highlights on the left and right ink in red. The ink language matches you, the majority, with the dissent in terms of the issue that they are describing. The same goes for the red. So let's start by looking at the ink in terms of how the majority describes the victim of the rape. They start out by stating that the prosecutrix was a 21-year-old mother of a 2-year-old who was separated but not divorced. She left her son with her mother and went to a high school reunion where she went bar hopping. Now that is a version of the facts that the majority adopted, and we can see in there already various implicit biases, from calling her the prosecutrix rather than the victim, or using her actual name, to the idea that she essentially dumped her kid with her mom and went bar hopping, which itself paints a picture of a particular kind of person. Now, when we look at the dissent, we see a different approach which seeks to tell a different story with the use of language, and here we have the dissent identifying her as a victim and giving her a name and identifying that she went to her reunion, the friend, and that she asked her mother to babysit her child so that she could go to this reunion because she was going to be home late, period. Now that tells a different story to a bar hopping prosecutrix dropping her kid at her mom's house to go get drunk, obviously. And I think it's a good example of how the framing with language can tell very different stories. The highlighted red language that you can look at demonstrates the same disparity, and so the lesson I think here is in civility is that 1, the basic norms we use are tripped, and 2, if courts see people so differently and there is an actual disagreement, that alone counsels in favor of proper decorum in describing the participants. As we go back to our civility guideposts, this is an example of objectivity being lost in the accurate rendition of the facts, which the dissent brings out. That lack of civility in accurate representations of facts damages the parties, the lawyers, and the system significantly when it comes from judges. And we will, at the end of the program, return to our judges and civility standards again. This wraps up the 3 advocacy foundations that are damages by a lack of civility, and conversely, advocacy advantages you can build by behaving in a civil manner consistent with the guideposts. But let us also now turn to actual cases where the civility principles play out in court cases to great injury to lawyers who trip lines. While the state bar standards we have looked at are voluntary, and we will look at the pledge that we are all able to voluntarily sign on to shortly, these civility standards are not only aspirational. Civility is a practice as demanded by courts and will lead to sanctions if tripped. Let's start with the federal rules of civil procedure, which are similar to most of our state civil codes, and we will use the deposition as an example. Lawyers must conduct the examination and cross-examination of a deponent in the same manner they would do as they would at trial. If you think back to our video clips and ask the question of whether this federal rules-based civility standard was tripped, I would submit to you that the answer is pretty self-obvious. Think of those examples of videos we watched and ask yourself if you as a trial lawyer would behave that way in front of a jury, or if you as a transactional lawyer would want one of your clients represented that way in front of a jury by your outside litigator. The question all but answers itself. And this civility standard of Rule 30 has teeth. As you can see here in Rule 30d2, there are sanctions that a court may impose for violations of proper deposition decorum. And you see here a prototypical Eighth Circuit case I have cited for you, which provides that sanctions for argumentative objections, suggestive objections, and directions not to answer may well constitute actionable conduct for sanctions. So in this sense, we have some civility standards that are not aspirational but can be enforced by sanctions. In this sense, the best way to not violate these civility rules is to not be lacking in civility in all respects. That is the safest approach. Let's take a look now at this Seventh Circuit civility case involving legal incivility by lawyers. Here we have a lawyer taking a deposition and asking largely irrelevant and at times harassing questions. The lawyer defending the deposition did not suspend it and go and bring the matter to the judge or seek a protective order to control the deposition, but instead engaged in the same behavior that lacked civility. The lawyer, frustrated, instructed the witness simply not to answer anything. At the same time, the deponent, who was himself a lawyer, suddenly acted as if he couldn't remember or understand basic questions. Now, in this case, when the matter was put before the district judge found that everyone had behaved inappropriately, and so therefore declined to sanction anyone. When that went on appeal to the Seventh Circuit, it reversed, and you can see the quote here, "Mutual enmity does not excuse a breakdown in decorum. If there is a breakdown in civility and professionalism, then sanctions should follow." As a result, the court censured 3 lawyers, including the deponent, admonished another lawyer who was present, and warned that any repetition of that conduct will lead to even sterner sanctions, including potentially disbarment. So now you can see those videos we watched filtered through both the aspirational civility guidelines and also through the narrower lens of discovery sanctions, which give the court some power to control civility before them. And just quickly, so you do not think I have cherry-picked a given case, this principle is legion across the country in all districts, and so I give you here a few more citations to similar holdings, so you know that I'm not giving you something that is anecdotal. First, the DeVille case reported at 419 F.ed. Appendix 201. Formed the Third Circuit in 201. This case upheld sanctions for abusive, unprofessional, and obstructive conduct during a deposition. Second, we have Google making an appearance, this time in Illinois, and here the court imposed sanctions for speaking objections that obstructed the deposition. Finally, the case of BNSF versus San Joaquin Valley, reported at 2009 Westlaw 3872043, formed the Eastern District of California in 2009. There, the court imposed sanctions for inappropriate and burdensome objections. All 3 are examples of stability breaches that lead to actual sanctions. Now let's double-click on the lack of civility that can occur by commentary and statements that is fundamentally inappropriate and lacking in civility for lawyers. First, we have a case of an objecting lawyer advising opposing counsel that she should not raise her voice because, quote, "It's not becoming of a woman or an attorney who is acting professionally under the rules of professional responsibility," end quote. That case is from the Northern District of California in 2016. It led to sanctions, and as you can see from our civility guidelines, it tripped a few of them. Second, we have a case of statements to opposing counsel during a deposition such as, "Shame on you." You know, someone apparently didn't fill you in on who you're dealing with here. And it appears you might be hallucinating by positing the possibility that the defendants are going to win this lawsuit. Now stop and look at those quotes from that case and compare them to some of the comments we saw in the clips we played. There is tremendous similarity. Here in this case from the Southern District of California, also in 2016, it too led to sanctions for those types of comments. Again, it comes back to the civility guidelines that can be incorporated fundamentally into actionable borders by courts. And the important point that we have been talking about today is that if you end up in this scenario, you have immensely damaged your credibility by that kind of behavior that lacks civility. In all those cases, the lawyers who were sanctioned were damaged in terms of how the court perceived them, which necessarily means the court's perception of your client and case is weakened. And those lawyers lost their standing with the opponent, which means it will be harder for you to resolve the case, which is always likely to happen. especially since, as we know, over 95% of all cases settle anyway. Knowing that on the front end, you want to be in the best position possible to have a conversation and dialogue with the opposing counsel, and a lack of civility actually damages your ability to do that. So I hope in all of this, one of the major pitches I make to you is that the concept of civility that in our guidelines is aspirational, even outside of the areas where it has teeth such as sanctions for discovery misconduct, it should be a good, powerful guiding pole star because it actually makes us better advocates. And at root, who among us does not want to be the best advocate we can be? This brings us to judges gone wild in civility. We will start in Chicago in 1918, and this is the case of Berger versus United States. It's reported at 255 U.S. 22 from 1921, and here we see Judge Landis in action with some anti-German hatred. Yes, you heard it right, so let's talk about it. The facts are as follows. It is World War I, and there's an espionage case being brought against German Americans for ostensibly helping the German war effort. And of course, the Germans were our enemies in World War I, and so these defendants end up finding themselves in their criminal case before Judge Landis. I don't know if he was tied up doing his baseball work at this point or not, but he was still a district judge, and so here is what Judge Landis actually said on the record. And these are quotes again that I took from the Berger versus United States opinion from the Supreme Court. This is what Judge Landis said, quote, "One must have a very judicial mind indeed not to be prejudiced against the German Americans, because, quote, their hearts are reeking with disloyalty." He went further. Another quote, "If anybody has said anything worse about the Germans than I have, I would like to know it so I can use it." End quote. I know you're all scratching your head saying, "I can't believe it, you can't make it up." Yes, it's true. They're in the opinion, and the third quote is as follows. "You are of the same mind that practically all the German Americans are in this country, and you call yourselves German Americans. Your hearts are reeking with disloyalty. I know a safe blower. He's a friend of mine who is making a good soldier in France. He was a bank robber for 9 years. That was his business in peacetime, and now he is a good soldier. And as between him and this defendant, I prefer the safe blower." End quote. So in any event, you can imagine a judge who feels that way about Germans in a case involving German Americans and espionage, didn't go well. And so this case made its way up to the United States Supreme Court. The Supreme Court ultimately held that the prejudice involved here by the judge was so profound, the judge simply should have recused himself from hearing the case of Berger versus United States. Luckily, none of us have to appear before Judge Landis, but he was simply recused from the case. No financial punishment, no impeachment, no sanctions in terms of case assignments. Instead, an order to recuse. Life went on for Judge Landis. And this is an early example of the limits of judicial judging of other judges in terms of actually issuing remedies to alter behavior that is at root unprofessional, improper, and lacking in civility. Now that is the early 20th century. But we have one for you from the early 21st century too. And just so you can see, a lack of civility from the bench is not something that is relegated to the early 20th century. It continues into the 21st century. This brings us to Topeka KS in 2006, and we will look at the case from the 10th Circuit reported here. The basic facts are as follows. There was a Hispanic defendant who pled guilty to a crime. Sometime later, he moved before the court to withdraw his plea of guilty on the basis that he thought he had received a promise of a particular sentence. This occurred notwithstanding the fact that the original plea colloquy involved a discussion where he agreed no promise of a sentence had been made. The judge was frustrated, and you can see here what he said. "I will not put up with this from these Hispanics or anybody else. I've got another case involving a Hispanic defendant who came in here and told me that he understood what was going on and everything was fine. And now I've got a motion from him saying he can't speak English and he didn't understand." You can see the full quote of it there, and this then led to a denial of the motion to withdraw the plea and an appeal up to the 10th Circuit. The 10th Circuit concluded that the statements were improper and the judge should have been disqualified under ethics canons. As the Court of Appeal said, the judge's statements on the record would cause a reasonable person to harbor doubts about his impartiality, without regard to whether the judge actually harbored bias against the defendant on account of his Hispanic heritage. So we can see judges angry at Germans and angry at Hispanics, all of which involve behavior that tripped ethics canons and also violated the civility norms that we have talked about in this program here. The civility guidelines that we have looked at principally through the prism of application to us as lawyers also should be understood within the ethics realm in terms of the behavior that we expect of our judges. Here we can look at a few of the canons from Section 4 of the guidelines and engraft them onto our two judges. In Section 4D, respecting cultural diversity, an attorney should not disparage another's personal characteristics. And Section 4A conduct should be consistent with high respect and esteem for the civil and criminal justice system. I think it is safe to say that these judges violated at a minimum those aspirational guidelines. And if you want to take a full look at the wild cases involving unbelievable judicial behavior, you can find my ethics program called Judges Gone Wild, as well as a separate program on the Supreme Court and ethics hypocrisy in terms of their behavior as it compares to other judges and lawyers' behavior. So this is the actual attorney's blood that the California civility work from the California State Bar has generated and created, which lawyers can voluntarily pledge and adhere to. It reads as follows, quote, I commit to these guidelines of civility and professionalism and will be guided by a sense of integrity, cooperation, and fair play. I will abstain from rude, disruptive, disrespectful, and abusive behavior and will act with dignity, decency, courtesy, and candor with opposing counsel, the courts, and the public. As part of my responsibility for the fair administration of justice, I will inform my clients of this commitment, and, in an effort to help promote the responsible practice of law, I will encourage other attorneys to observe these guidelines. End quote. You can sign it and send it back to the State Bar if you want. Let's now go back to where we started with that first video and assess it under our civility standards we have been exploring today. We will watch it again and then go through the checklist.
Did you talk to this man sitting next to you before this deposition started?
Yesterday, but he had nothing to do
I
with
didn't
what
ask
you
you
are
that.
currently saying. I said it, though, didn't I?
Did you talk to him, sir? What did you say?
I said nothing. I said you have a case of incipient verbal diarrhea.
Oh, sir, we're going to see about that.
Well, good.
Did you talk to him yesterday?
Yes.
How long?
About 3 hours.
Talk about this case?
Yes.
Did you tell him the other companies you consulted for?
No.
You're under oath here.
I did not.
We'll see about it. When you were at Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
Research chemist.
And was that your title during your entire stay at Texas City?
Texas City, yes.
Don't talk over each other.
After you left Texas City...
Wait a minute, let me ask a question here.
Yeah.
Do you represent this guy or not?
Who are you?
My name's Tucker, and I represent Ayrshire, and I just want to know, do you represent the guy or not? I'm getting, if you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Why don't you keep your mouth shut and I'll do what I want.
No, you're not going to do what you want.
Oh, wait.
I'll do what I want.
No, you're not.
No, you're not.
Yeah, I am.
That's
I'm gonna
bullshit.
make whatever objections I want to make, and I'll make them as loud as I want to make them. Or you just shut your mouth and we'll keep the record straight.
Don't tell me to shut my mouth, boy. You may be big, but you won't see how bad you are. Come on.
And I wouldn't try that, Ed.
Are you threatening to fight?
Hold on just a second.
No, I want to know whose side we're on. We're going to be outnumbered, Ed.
Hold on just a second.
No, you got a big mouth. Now, you do. Now, you need to either represent the man or not.
I'm
Not tolerate
representing Monsanto, and I'm
But
making
you're
an
not-
objection on the record.
Then you're not entitled to be his lawyer then, okay?
I'm not representing the man.
Well,
I'm
you're
making
trying
an
to be.
objection on the
And
record.
another thing,
Don't tell
you
me what
don't.
I'm trying to do.
Yeah, I'm going to tell you something else. You don't run this deposition. You
Neither
understand?
do you, Joe.
You
Neither
watch and
does
see.
he.
You watch and see who does, big boy.
I'm telling you, Joe.
Oh, you ain't telling me a goddamn
I'm gonna make
thing.
whatever objections I want.
You can
to
make your
on the
objections
record.
and
You can
keep
talk as loud
quiet.
as you
See?
want. No,
But
I'm
don't be
not
telling
gonna
another
keep
lawyer
quiet.
to shut up.
Don't be
That
telling
ain't your
me to shut
goddamn
up.
job,
No, that's not
fat
your
boy.
job.
Now
Mr.
get back.
Hairpiece.
Now you got
As
you
I
got
said
time to answer
before,
me?
you have an incipient bad
What do
mouth,
you want
don't
to do
you?
about it, asshole?
Oh, I'd like to knock you on your ass.
Come
I'm
try
not
it.
gonna do
Wait a
that.
minute.
Come over here and try it,
Wait a
you
minute.
dumb son of a bitch.
Wait just a second.
Come over here.
Hold it. Hey, wait a minute. Hold on.
Come over here.
No way. Hold on. Hold on.
Why don't-
Hold on just a second.
associate of taking Mr. Garrett out in the hall to lecture him, I suppose. That doing this over our objection, we started this deposition, unable to get an answer from this man.
Let's run through our civility guidelines after watching that. Guideline 4A. An attorney's conduct should be consistent with high respect and esteem for the civil and criminal justice systems that seem to be tripped by all. Guideline 4C. An attorney should not disparage the intelligence, integrity, ethics, morals, or behavior of the court or other counsel, parties, or participants when those characteristics are not at issue. That was tripped by multiple people in multiple ways. Threats to fight, telling people to shut up, and big boy put-downs. Guideline 4 days. Respecting cultural diversity, an attorney should not disparage another's personal characteristics. Here, the big boy comment seems arguably to be putting down someone for their weight or size. Check again. Guideline 4F. An attorney should avoid hostile, demeaning, or humiliating words. Across the board violated. Well, that clip has it all. Something for everyone. We saw some staggering clips today, which I go back too many times, and I'm simply blown away by them. I hope you found them useful as learning tools for our program. Today, we have looked at the California Civility Guidelines, which have principles that are aspirational in the sense that they are not enforceable by the California State Bar as written, and we have been grafted them onto a variety of behaviors that lawyers engage in. Our principal focus has been to illuminate how voluntary compliance with civility guidelines actually makes us better advocates and lawyers, thereby enabling us to do a better job for our clients. In this sense, being civil is a win, not just for the system in some macro policy sense, but in a macro sense for us and our clients. As a result, we looked at how civility impacts our persuasion tools, so that within the rubric of the California education requirements on civility and effectiveness, we can actually see the tangible benefits in a skills setting to stability. We looked at issues related to credibility, objectivity, building credibility, losing credibility, and we considered the idea of concessions, that is, falling on the sword when necessary to actually build credibility. We see fundamentally how credibility can be ruined by giving someone an advantage they did not have to be given and which they did not start with. And a lack of civility can do exactly that. We looked at multiple different cases where this type of behavior lacking in civility has led to sanctions awards, which have far more damage to one's case than perhaps the few $100 or $1,000 that have to be paid in sanctions. You have actually damaged your overall case in terms of how the court perceives you and, as a result, your case and client. The best advice is not to engage in improper conduct and thereby become a part of the problem yourself. We saw that in some of the example cases and also the videos where one lawyer starts out causing trouble, but the other one rises to the occasion and joins. And we saw another case where a court ultimately sanctioned all the lawyers for improper behavior. We also stopped along the way and saw how the witness's ill behavior can become your problem, and also how a lawyer managing a very difficult and hostile witness can handle it in a manner that is actually respectful and civil without breaching the standards. There we saw it in that clip of Lil Wayne. In this sense, I wanted to give you clips on each side of the civility line, and that one was good because the lawyer did not rise to the bait, even though it must have been tempting given just how improper the witness was behaving. Civility matters because we are better advocates when we follow the guidelines of civility, even though they are aspirational and not enforceable. But remember, many of them are functionally enforced through the power of courts to sanction discovery abuses and other improper behavior before the court. We went through all the guidelines, and they are very good guidelines for you to keep in mind and follow, not only because you want to be a more civil lawyer, but also because that will make you a better lawyer and avoid the risk of sanctions or case damage. Finally, I think it's safe to say, be civil, because in this modern world of everything being recorded, you don't want to get caught on tape and show up in part 2 to this program. It's been my pleasure talking to you today and sharing this program with you. As always, if you have questions, please feel free to email me, as I am happy to engage in discussions with you at any time about these issues.